Parles-tu français? Hablas español? Parli italiano? If you've used Babbel, you would. Babbel's conversation-based techniques teaches you useful words and phrases to get you speaking quickly about the things you actually talk about in the real world. With lessons handcrafted by over 200 language experts and voiced by real native speakers, Babbel is like having a private tutor in your pocket. Start speaking with Babbel today. Get up to 55% off your Babbel subscription right now at babbel.com/Wondery. Spelled BABBEL.com/Wondery. Rules and restrictions may apply.
Judge Boasberg's colleague in D.C.
And the former chief judge of the same court.
Right.
That was abusive. But it's a whole lot worse when it is under the auspices of the federal government itself behaving like this, right? Like the very fact that such a document was filed makes it clear exactly why the Department of Justice is not entitled to the presumption of regularity, right? The Justice Department should not be doing stunts.
Welcome to Law and Chaos, where we are filing a FOIA claim, and the Trump administration is violating the Posse Comitatus Act, and Alan Dershowitz can't get a dumpling. We got a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Dye, and with me, as always, is Andrew Torres. Andrew, how are you?
I am wet.
Yeah, it's pouring.
It's
pouring. We're having a monsoon here in the Baltimore area. I hope you guys are not getting flooded wherever you are.
But other than that, how are you, Liz?
I'm looking forward to the weekend. I spent a lot of time with my kids. It's been good.
That's wonderful.
Okay, let us talk about the biggest news story of the day, which is obviously Pierogi-gate, the greatest scandal to hit Martha's Vineyard since Larry David yelled at Alan Dershowitz for supporting fascism.
This feels like it's going to involve Ina Garten in some way, maybe?
No. That's the Hamptons. Get it together, dude.
Okay.
It does, however, involve Alan Dershowitz again, because Dersh has been whining for years that none of his liberal friends will hang out with him at the beach anymore. And now he's been canceled and no one will invite him to brunch, which is illegal.
Is it? I feel like it's not, actually.
Yeah. Well, I know that he didn't sue Larry David. And he did not sue the Chilmark Library, although he made such an unholy ruckus in 2022 about not being allowed to speak that Proud Boys threatened the poor librarian. And as the child of a former public school librarian, may I say, anyone who attacks librarians is going to hell for all eternity. The reality was that he failed to submit his application to speak in timely fashion, and there were no more speaking slots. So in 2023, he submitted his application on time, along with an apology letter to the Board of Trustees, and was allowed to give his speech. The Vineyard Gazette reports that some people actually stood in line to ensure that they got in, but the room never reached its 25-person capacity, and no one was turned away.
It's standing room only. Anyway, shocker.
Yeah. So it's July again, or at least it is while we're recording this. So Dersh is engaged in the time-honored summer ritual of threatening to sue his neighbors. This time he's mad because the pierogi vendor at the farmer's market wouldn't sell to him, which he says is McCarthyism, on a 30-minute podcast, which we do not get paid enough money to listen to.
Not even if we hadn't spent 2 hours this morning listening to the Department of Justice try to convince the Federal Circuit that Trump totally has the authority to do tariffs whenever he likes.
No, not today. And as we like to say on the podcast, not ever. So according to news reports, Dersh explained that his Ukrainian Jewish bubby used to make pierogis, and these that they sell at the market aren't as good, but he'd like some anyway. But the vendor said they aren't going to sell to Dersh because they don't like his politics and they didn't like who he represented, which Dersh took to mean Trump. And yeah, that could be. But this guy has represented a bunch of unsavory characters.
Yeah, he negotiated the plea deal for Jeffrey Epstein down from sexual assault of minors to solicitation of prostitution. Dersh also famously represented O.J. Simpson, Klaus von Bülow, and, pretty much everyone who sold porn in the 1970s. So rich vein to mine.
Yeah, I mean, I'm not going to ding him for his clients. Everyone is entitled to competent counsel, but I think his behavior has been somewhat less than exemplary in multiple contexts. So Dersh started making a scene at the market, and a cop came up and tried to calm him down. And now he says he's going to sue the farmers market to make them serve all commerce.
So, okay, Professor Dershowitz, private establishments have the right to refuse service to whomever they like. Now, you cannot exclude someone who's in a protected class like race or national origin. The pierogi stand couldn't refuse to serve all Russians or whatever out of solidarity with Ukraine. But I'm trying to figure out what protected class Alan Dershowitz is in.
I think it's old guys whose wife and kids don't love them enough to unplug the router and stop them ruining a legacy built up over an entire lifetime.
Whatever remains of that legacy, yeah.
Yeah, don't worry. I'm sure that the Trump DOJ is already on the civil rights complaint against the farmers market on Martha's Vineyard.
I wish you were joking.
Yeah. Okay. Next up, let's talk about a sleeper case, which I think is going to come back around soon in a big way, which is Newsom v. California, where the state sued to get troops off the streets after Trump said that resistance to ICE constituted an emergency and federalized the state's National Guard. But before that, actually, maybe we want to do a bit of refresher on the Posse Comitatus Act. Andrew, do you want to do the honors here?
Sure. The Posse Comitatus Act of 1878 was codified at 18 U.S. Code, Section 1385. Very short. It says, whoever, except in cases and under circumstances expressly authorized by the Constitution or Act of Congress, whoever willfully uses any part of the Army, the Navy, the Marine Corps, the Air Force, or the Space Force as a Posse Comitatus or otherwise to execute the laws shall be fined under this title or imprisoned not more than 2 years or both. And the Posse Comitatus Act, let me kind of put it into context, because before 1878, it was presumed that the president had the power to use the military to help states enforce the law, right? Indeed, particular federal statutes pre-1878 sometimes specifically authorized recourse for the Posse Comitatus in order to enforce that law. And the key disgraceful example here is the Fugitive Slave Act, right? So under the Fugitive Slave Act, slave owners whose slaves had escaped to another state were entitled to go get an arrest warrant for those slaves and have that warrant executed by federal marshals. And the marshals, in turn, often would, quote, summon and call to their aid the bystanders or Posse Comitatus of the proper county, and all good citizens were commanded to aid and assist in the prompt and efficient execution of this law, wherever their services may be required as aforesaid for that purpose. I'm quoting from the Fugitive Slave Act. Now, that was using local law enforcement as Posse Comitatus. But as you might imagine with the Fugitive Slave Act in the North, the local military was often unwilling to help federal marshals track down escaped human beings. So in 1851, President Millard Fillmore issued a presidential proclamation requiring the federal military to aid and assist by all means in their power in enforcing the Fugitive Slave Act, and sent federal troops to Boston. After the Civil War, in 1878, Congress passed the Posse Comitatus Act in essentially the form that it remains in today and said, yeah, we're not doing that ever again.
Right. So we've talked on the show a fair bit about this case, Newsom v. Trump. That's the one where Judge Charles Breyer said that it was not legal for Trump to federalize the National Guard without consent of the governor. And the judge said that there was no actual emergency, so the National Guard had to be returned to control of the state. The Ninth Circuit stayed that order when the government appealed, but that didn't dispose of the plaintiff's secondary argument that troops were violating the Posse Comitatus Act by engaging in law enforcement.
Yeah, and I think it's important to flag procedurally what happened here, because this is the inevitable result of circuit courts of appeal and the Supreme Court jumping the gun and letting the Trump administration immediately appeal any order they don't like. Because what Judge Breyer did was grant a temporary restraining order on the National Guard federalization issue with a very tight briefing schedule and said, hey, when we come back to debate the preliminary injunction, that's the thing you are allowed to appeal, we will have some actual data on whether the federalized troops are engaged in law enforcement in violation of the Posse Comitatus Act. Because remember, a TRO runs at maximum 2 weeks. Okay, it can be renewed once, but no more than 28 days ever. A preliminary injunction lasts through the trial. But as always, the Trump administration did not wait to see. And so when the Department of Justice took an appeal, it only appealed the issue of the National Guard deployment because Judge Breyer had not yet ruled on the Posse Comitatus issue. And the government, with the help of the Ninth Circuit, short-circuited that process. And now this case is bifurcated. It's a mess, right? Well, at least as to remedy, right? I mean, it's all back before Judge Breyer, since the case will still go to trial on the federalization issue. But in the meantime, there's a very real possibility that Judge Breyer will say that Homeland Security is violating the Posse Comitatus Act and order some kind of remedy, which will mean the case will then go back to the Ninth Circuit once more for emergency relief.
Right. So that is a mess. And unsurprisingly, the government says it is not violating the Posse Comitatus Act. And Andrew, you and I were talking about this when we were planning a show, and we agreed that maybe our side had kind of set the bar too low because we said it would violate the Posse Comitatus Act for troops to arrest people. And look, you had military commanders when this deployment started saying that they had the authority to briefly detain people to allow ICE to arrest them. And we were like, hey, any detention is an arrest. So ipso facto, there's your Posse Comitatus violation. But I worry that we made it sound like if troops weren't doing arrests, then they were definitionally not in violation of the Posse Comitatus Act. And that's just wrong.
Right.
Let me read you a bit from California's brief, which was filed yesterday. They said, since plaintiffs filed their motion for preliminary injunction, the evidence of Task Force 51's direct and active involvement in civilian law enforcement operations has only grown more extensive. On June 19th, 2025, defendants deployed federalized National Guard troops to Mecca, California, over 100 miles east of downtown Los Angeles, during a law enforcement operation at a cannabis farm. The federalized National Guard troops engaged in civil law enforcement activity by forming a, quote, security perimeter around the marijuana farm where the operation was taking place, thereby preventing civilians from entering and exiting.
Yeah, and look, I am not a criminal lawyer, but that certainly sounds to me like a detention if you cannot leave. If the troops were explicitly there to stop people from leaving, they are detaining them for constitutional purposes. But even if that operation doesn't meet the definition of detention for Fifth Amendment purposes, it's clearly a law enforcement operation, right? The troops are not there to protect law enforcement. They're participating alongside them. And in fact, the complaint says that the National Guardsmen formed a perimeter during other police actions, standing alongside ICE to, make that perimeter.
Yeah, so that to me seems like a pretty good argument on its face. And the complaint alleges that the troops have actually detained people on at least 2 occasions.
Yeah, the federalized National Guard troops.
Right. But again, this brief really made me think about my own priors here, because I was thinking, okay, they can be there to protect law enforcement agents and maybe they form a cordon around the agents. I really wasn't thinking of them as forming a cordon around the whole operation.
Mm-hmm.
And I wasn't thinking about protecting the agents as violating the Posse Comitatus Act. But reading this brief, the state makes the argument that if the National Guard or the Marines weren't there, then DHS would just have to deploy more ICE agents for backup. And so functionally, these troops are standing in and doing ICE's job for it, which is civilian law enforcement. So this brief makes a pretty compelling argument that DHS is just conscripting state militias to fill in for its own lack of manpower, which would, I think that's a good argument that this is definitionally a violation of the Posse Comitatus Act.
I do. I agree with that. I think 2 things that have come to mind. The first is absolutely it is worth pointing out that making arrests is not the language of the statute, right? The statute is enforcing civil law. And so that can occur, as you point out, as the brief points out, even if it isn't the federalized troops themselves who are detaining individual, immigrants. The second point that I think is good, and I want to make sure we've teased out here properly, is that this process is about assembling a record. And the question is, where's the best place to do that record? And the answer is the trial court, right? And that's what we've lost throughout all of this. And the administration wants to confine this to a high-level debate because they want to slice that salami really, really thin, right? Like, it is permissible to deploy federal troops to protect local law enforcement, to stand in front of them, to have their body armor on, that sort of thing. But once they've, right, that the line between protecting the officers and aiding and assisting the officers is really, really thin, and it's fact intensive, and that's what trial courts are for.
Yeah. And I just want to add before we leave this segment, I was listening to LA Mayor Karen Bass on the New Yorker radio hour last week, and she said look, this was clearly a test case for the nation, right? They paraded these troops around they paraded them through MacArthur Park during, breaking up. The kids were in summer camp at MacArthur Park and they had to go inside because it was so scary. It's all these, there's a lot of Latino kids. They are terrified that these are troops that are coming to take their parents, just like horrible shit. And that LA is a test case for the militarization of our cities, the militarization of law enforcement, for the Trump administration to kind of march through on display and horses and all of this other crazy stuff as a show of force to cow blue states and blue cities into cooperating with their immigration priorities. And I mean, I don't think it worked in Los Angeles. And I think that they said basically they would be there for 30 days and the 30 days is elapsed. So they've sort of slowed down raids there. But I expect we'll see it, in New York and Chicago. We live in Baltimore, possibly here. I mean, although we're pretty small potatoes. But places which are strong blue states with strong sanctuary city policies, I think are going to be a continuing target for this administration. It's very clear that they are.
I think that's exactly right.
Okay, we are going to take a break unless you are a subscriber at patreon.com/lawandchaospod or lawandchaospod.com, in which case, not for you. And we are back. Okay, breaking Achtung. Attorney General Pam Bondi has a lot of chutzpah.
I mean, it's not news, but I do agree with you. She really did outdo herself this week.
We are talking, of course, about the judicial ethics complaint filed against Chief Judge James Boasberg in the U.S. District Court for the District of Columbia, a complaint she purported to file to protect the integrity of the judiciary.
Oh, yeah, and then she congratulated Emil Bovee for getting confirmed to a lifetime seat on the Third Circuit, one step under the Supreme Court, because Pam Bondi really cares deeply about the integrity of the judiciary. No,
yeah.
Sarcasm aside, it is utterly craven for the Trump administration to claim to be protecting the judiciary by constantly attacking judges and implying that they are illegitimate partisan actors. And Trump does that 7 days a week.
Right. So we wrote about this at the website, lawandchaospod.com. Here is the broad outline of our post. The Justice Department is whining to Chief Judge Sri Srinivasan of the Court of Appeals for the District of Columbia that during a breakfast meeting of the Judicial Conference in March, Judge Boasberg said that he was worried about the Trump administration disobeying a court order.
Which they did. The Washington Post has reported that the Trump administration has violated 1 in 3 trial court orders, and they're likely to continue doing that thanks to the Supreme Court, letting them get away with it.
Yeah. So now the Justice Department's Chief of Staff, Chad Mizell, is crying to Judge Srinivasan that this statement by Judge Boasberg, alleged statement, amounts to intimidation of poor defenseless Chief Justice Roberts. And this is a public statement undermining the integrity of the judiciary in violation of the judicial canons of ethics. Judge Srinivasan was, by the way, in the room during this purported discussion at the Judicial Conference. So I expect he knows what happened there and wasn't that pressed about it. But Mizell demands that Judge Srinivasan sanction, possibly impeach, and definitely remove Judge Boasberg from that JGG case involving the Alien Enemies Act detainees.
No, he doesn't. I mean, yes, Mizell would love that, of course, but he and Pam Bondi know damn well that this complaint is going nowhere. What they want to do is win the news cycle and feed their right-wing trolls. They want to undermine the integrity of the judiciary. That is the entire point of this exercise.
Yeah, that's like 50% of what the DOJ does these days. But I agree with you that this is about the media. And in fact, this entire thing is created by the media. I mean, look, the comments at the Judicial Conference were not public comment at all. They were in this closed confab, and there's no transcript or summary available to the public. The only evidence that this ever happened is an offhand reference in the complaint itself to, quote, attachment A at 16. And attachment A is not attached, or at least not to the version that they published, all over the internet and gave to every reporter in D.C. The only other mention of such a document was at the Federalist, that's the right-wing weirdo website, by weirdo reporter Margot Cleveland. She published an article on July 16th claiming to have a 20-page memo with minutes of that meeting, and no, she will not be sharing that memo with us, but she will be quoting from it, at least briefly. She has 2 quotes. The first says, Chief Judge James Boasberg next raised his colleagues' concerns that the administration would disregard rulings of federal courts, leading to a constitutional crisis.
The word colleagues there seems to me to be pretty important, right? The DOJ complaint implied that Boasberg was raising his own concerns, which seems a little bit unethical.
Oh, you think? And the second quote in the Cleveland piece says, Chief Justice Roberts expressed hope that would not happen, and in turn, no constitutional crisis would materialize, according to the memorandum. The summary of the working breakfast added that Chief Justice Roberts noted that, quote, his interactions with the president have been civil and respectful, such as the president thanking him at the State of the Union address for administering the oath.
Chief Justice John Roberts, who is constantly complaining about attacks on the judiciary, said, it's fine because Trump thanked him and we won't forget all you've done for us at the State of the Union.
Oh, yeah. I think it's very funny that whoever wrote this memo said that the president was thanking Chief Justice Roberts for administering the oath. Like, no one in the room thought that is why Donald Trump was thanking the Chief Justice. Everyone understood that as to be, thank you for what you did for me in the courtroom.
Yeah, in the immunity case in particular.
Correct.
Absolutely.
Obviously. And it's very funny because Chief Justice Roberts was standing next to his colleagues, including Justice Amy Coney Barrett, who got caught like cringing so hard, that her hair stood on end and rolling her eyes because it was so wildly inappropriate. And so it's just very funny that whoever wrote this memo, assuming that it's a real memo and not a fakery, refers to it as the president thanking him at the State of the Union address for administering the oath, and Chief Justice Roberts being so gratified by this blandishment.
Yeah, I don't want to suggest that Margot Cleveland made this up, but what I do want to say is that it sounds specious that Chief Justice Roberts would engage in something that looks somebody who cares so much about his public appearance of trying to be calling balls and strikes would so obviously not call balls and strikes. And look, if it's true, things are way worse than what we thought, right? And I should say, Liz, you and I went through the list of the attendees at this conference. There's only 26 of them. We tried to figure out if there was some lunatic Trump appointee on there. We didn't find one. And that's because the Judicial Conference makes these recommendations, sets budgets, and it is comprised of the chief judge of each of the various circuits and one judge, usually also the chief judge of a district court sitting under each of those circuits. And these all tend to be older appointees. But maybe we're going to find out. Thanks to our friend and lawyer, Kel McClanahan of National Security Counselors, who filed a FOIA request for us on Monday night, demanding that the DOJ cough up Attachment A. And I don't think I can explain it better than Kel did when he gave us a quote for the article. So I'm just going to read it. He said, FOIA applies to all agency records. It's the Freedom of Information Act. Applies to all agency records. It does not apply to congressional or judicial records, but it does apply to records which originated outside an agency, but were later put into the agency's files for its own purposes. When this record was created by a judge, it was not subject to the Freedom of Information Act. When it was leaked to Cleveland, it was not subject to the Freedom of Information Act. When it was given to the Department of Justice, it arguably became an agency record, but you can make an argument that it still wasn't. But when the Department of Justice explicitly used it to create a complaint to be filed with the D.C. Circuit, it indisputably became an agency record and therefore undisputedly subject to FOIA.
Aha. So TLDR, internal agency documents aren't always subject to FOIA, but when they move between federal branches, in this case executive to the judiciary, they become public documents subject to FOIA.
Yeah, cough up Exhibit A, Chad.
Uh-huh.
Okay, so a couple of points that we weren't able to get into in the post that I want to flag here. The first is that Chad Mizell complains bitterly about Judge Boasberg refusing to extend the presumption of regularity to the Department of Justice. That is, the underlying assumption, true prior to this administration, that courts should extend to the government that it is behaving appropriately and dealing honestly with the court. And again, pretty ballsy to cry angry tears over that when the government has been anything but honest in the JGG case in particular, right? Like, that is the one where we have the whistleblower report from Erez Ruveni saying that attorney Drew Ensign lied to Judge Boasberg's face about flights taking off after the court had issued an order. And we have the contemporaneous evidence from Ruveni's texts proving that this was part of Emil Bovi's master plan to say F you to federal judges. So yeah, you have lost the presumption of regularity by behaving in a totally irregular, not to say unethical fashion. And not just in Judge Boasberg's court, right? You have had judges in at least 8 Immigration and Impoundment Act cases say that the government has lied and defied court orders. I mean, the Department of Justice spent months insisting that it had no control over the men sent to CICOT, and then it traded them to Venezuela for Americans held in Venezuelan jails. In the Abrego Garcia case, the government said it had no power to bring him back to the United States, right up until it dummied up an indictment based on a 2-year-old traffic stop, and then it flew Abrego home without even pretending to file for extradition. That is pretty goddamn irregular.
Yes, it is.
Just this week, Judge Royce Lamberth, one of the old bulls that you love watching so much, Liz, ordered Kari Lake and the U.S. Agency for Global Media, which she heads, to show cause as to how they are complying with his prior order and the statutory mandates to actually put out news, because what they're doing, paying USAGM employees to stay home and do nothing, that ain't it.
Yeah, that was actually the argument the Justice Department made, that it was spending the money allocated by Congress, and so case closed, all they had to do was spend the money, even if the way that they spent it was just to pay people that they had furloughed.
Right. And I want to make a second point, which is that the DOJ is explicitly engaged in partisan warfare here. They are using tactics which were borderline inappropriate when it was just Trump as a private citizen and his lackeys engaged in it. Like we said in the article, Representative Elise Stefanik filed 4 garbage ethics complaints in 2024 alone.
Yeah, she dinged not only Jack Smith, but 3 judges for being mean to Donald Trump. She filed one against Justice Juan Merchan, who presided over the criminal trial, the false business records case. She filed against Justice Engeron, who presided over the civil trial. And she hit Judge Beryl Howell, Judge Boasberg's colleague in D.C.
And the former chief judge of the same court.
Right.
That was abusive. But it's a whole lot worse when it is under the auspices of the federal government itself behaving like this, right? Like the very fact that such a document was filed makes it clear exactly why the Department of Justice is not entitled to the presumption of regularity, right? The Justice Department should not be doing stunts.
Yeah, and I would like to note that when someone filed a Florida bar complaint against Bondi for her unethical conduct, Mizell called it performative and vexatious. I mean, look, Trump and his lawyers have done so much breathtakingly corrupt and unethical shit, both in and out of office. And state bars at least state bars are kind of receptive to complaints against the worst actors, or at least they're starting to step up. Rudy Giuliani and John Eastman are no longer allowed to practice law. I mean, the Texas bar said Sidney Powell was still good to go, so that's nice. But today, the D.C. bar recommended disbarment for Jeff, we'll call you if there's an oil spill, Clark. He's
about time.
He's that form. Yeah. Well, to be fair, he appealed. He tried really hard to put the stay off. He's the former Justice Department lawyer who tried to use his office to provide legal cover for state legislators to steal Biden's electors in 2020 and give them to Trump by claiming to have found evidence of fraud, which they did not.
Yeah. I don't think this can be read as anything other than a very loud warning to current Justice Department lawyers that doing illegal stuff at the behest of the president will not shield you from professional sanctions. And again, it should not be up to the D.C. Bar Committee to be our, on the front line of enforcing the rule of law. But here's where we are. And here's what the order says. While dishonesty is always intolerable, the facts here are significantly aggravating to warrant disbarment. Respondent was prepared to cause the Justice Department to tell a lie about the status of its investigation of an important national issue, the integrity of the 2020 presidential election. Lawyers cannot advocate for any outcome based on false statements, and they certainly cannot urge others to do so. Respondent persistently and energetically sought to do just that on an important national issue. He should be disbarred as a consequence, and to send a message to the rest of the bar and to the public that this behavior will not be tolerated.
I mean, amen to that. And I will note that the decision was not unanimous, but the two dissenters, because it's a committee, the two dissenters said he should be suspended for 3 years, and then he should have to prove his fitness to be readmitted to the bar. So there was unanimity that what he had done was beyond the pale. And the New York Times reported this morning that the Legal Accountability Center, which is part of the Democracy Fund, filed bar complaints in D.C. against 3 Justice Department lawyers who appear to have lied to Judge Amy Berman Jackson in a case called National Treasury Employees Union v. Russell Vought. We've talked about that a bit on the show. That's the one that involves dismantling the CFPB. We will see how that complaint goes. But I do think we're in a very strange moment here where the Trump administration is indignantly demanding to be treated as if what it does is legit and above board and like every other administration that went before, and it is not.
No, I fully expect, I'm being serious here, that the Department of Justice will launch an antitrust investigation of the D.C. Bar Disciplinary Committee now, or otherwise try and transfer that authority to the executive branch. I mean, look, this is an administration that has already sued every federal judge in the state of Maryland for making a change to their standing orders. I mean, the lawlessness knows no bounds.
Yes, 100% agree. And I will say, I think that the DC Bar knows that and is willing to take the risk and is indeed, I'm reading this decision in the Clark case as a shot across the bow at all of these lawyers in the DOJ, because part of why this took so long, right? John Eastman was disbarred a while ago. Rudy Giuliani's disbarment was like 2 years ago or something. Part of the reason it took so long with respect to Jeff Clark is that Jeff Clark really tried to litigate this and say he was immune because he was acting on behalf of the federal government. And this DC Bar decision says, no, the fact that you are working for the president will not save you. And I think that this is definitely a warning to all of the lawyers in the Trump administration.
Yeah, I agree with that.
Okay, we're going to take another ad break, unless you are a subscriber, in which case, not for you, not today, not ever. And we're back. Okay, on February 1st, Donald Trump announced tariffs on China, Mexico, and Canada, ostensibly to fight transnational drug cartels. And then on April 2nd, he held that ridiculous Rose Garden ceremony where he wandered around with a poster board of reciprocal tariffs. He'd announced to combat trade deficits, which is supposedly a big emergency. That poster was the one that famously included economic powerhouses like Vanuatu and Lesotho and Ivory Coast and the Heard and McDonald Islands, which those last two appear to be only inhabited by penguins, but get on with your bad selves. Anyway, last week, Trump announced more tariffs that are supposed to kick in on August 1, although he said that he and Mexican President Claudia Sheinbaum are besties now, so he's going to give that country another 90 days to comply.
Yeah, Reed, someone told him what will happen if you tariff the shit out of our largest trading partner.
Yeah, so, I think it's basically a tie with Canada. But anyway, Trump has been vacillating for months on these tariffs, and of course it's causing some massive instability. First, he promised to strike 90 deals in 90 days, and he announced some deals, which appear to be tentative at best, maybe 4 or 5. None of those appear to be finalized. And now he says that he'll be sending out letters to all the rest of the countries we're trying to shake down tonight, as we're recording this. And those letters are the deals. In fact, they're better than we could have negotiated if we actually sat down and talked with other countries and got them to agree to something. And so we should all congratulate R.D. McDeals on his prowess.
As legal justification for this, the administration points to the president's emergency powers under the International Emergency Economic Powers Act of 1977, or IEPA. That is 17 U.S.C. Section 1701 et sec. That law does not say the president has the power to impose tariffs. And before Donald Trump's second term, no president in history, including Donald Trump in his first term, has ever tried to invoke IEPA as a basis for raising tariffs, which is why states and manufacturers sued to block those IEPA tariffs that Trump announced. And in late May, the United States Court of International Trade, which is a specialized court assigned to hear these kinds of cases, issued a permanent injunction blocking Trump's IEPA tariff orders, rescinding the changes made to the U.S. tariff schedule. And the Trump administration immediately appealed that decision to the U.S. Court of Appeals for the Federal Circuit, which issued an immediate administrative stay of that Court of International Trade order, ordered expedited briefing, set a hearing for July 31st, which is today as we're recording this, before the entire 12 judges of the Federal Circuit sitting en banc, not just a 3-judge panel. And that is what we listened to for 2 hours today. So,
yes, we did.
Yeah, let's set up the roadmap, right? The president does not have any inherent power in the Constitution to impose tariffs, because tariffs are taxes, and the power to lay and collect taxes, duties, imposts, and excises rests with Congress. That's Article 1, Section 8. Now, Congress may delegate some of its powers to the executive branch by legislation. That's how we got the administrative state. So here's the order of operations for how a court is going to look at this question. The first is, does IEPA give the president the power to impose tariffs? If no, then these are not valid, right? He was not delegated those powers by Congress. It goes away. Second, but if yes, it doesn't mean that the tariffs are still valid. Then you have to ask the question, is that delegation of powers from Congress to the president constitutional? And again, you go through the thing. If that's yes, you then move to the third question, which is what limits accompany that delegation to make it constitutional, and how can those powers be challenged in court, if at all?
Yeah, well, I think that they mean no to all. That would be the position of the Trump administration. Yeah. Okay, so let's start with IEPA, which was passed in 1977. IEPA says that if the president declares a national emergency, Congress will give him certain limited powers to, quote, deal with any unusual and extraordinary threat which has its source in whole or substantial part outside the United States to the national security, foreign policy, or economy of the United States. And one of those powers is to regulate importation or exportation in response to that emergency. Mm-hmm. So the Trump administration's argument is that tariffs are kind of regulation of imports, and IEPA was intended to be a broad statute, so it includes implicitly a delegation of the tariff power to Trump. Mm-hmm. And the way they get from point A to point B is through a doctrine called judicial ratification, which I'm going to call this one your walk-up music.
I hear the strands playing in the background, and we will get into that after this brief ad break, unless, of course, you are a subscriber at patreon.com/lawandchaospod or on our Substack over at lawandchaospod.com, at which point no ad breaks for you ever. And we're back. Okay, before the break, you called me up with the walk-in music, and I want to be clear here, because while I think the argument that IEPA gives the president the power to impose tariffs is not a very good argument, it's not preposterous, right? It's not laughable on its face. So I want to make the best case for it, right? So judicial ratification. That says that Congress sometimes uses the exact same language in passing a law that a court, and usually it's the Supreme Court, has used in a prior opinion. That is called ratifying that prior judicial interpretation. And so the administration's argument here is that when Congress passed IEPA, it was ratifying the language from a 1975 case, because IEPA was 77, from the U.S. Court of Customs and Patent Appeals, which is a predecessor to the Federal Circuit. That case was called United States versus Yoshida International. And let me just kind of give a brief background on that case. August of 1971, then President Richard Nixon imposed a temporary 10% tariffs on many goods to address what he called balance of payments problems, which is a trade deficit with other nations, right? So this is reasonably analogous to the present situation. That was Proclamation 4074. In that proclamation, Nixon did not cite authority for the tariffs. Those tariffs were challenged by a Japanese zipper manufacturer named Yoshida International. And then in court, the Nixon administration said that it got its authority for Proclamation 4074 from a statute called the Trading with the Enemies Act. And the appellate court, right, that Court of Customs and Patent Appeals, upheld the tariffs. They said, we conclude that Congress, in enacting Section 5B of the Trading with the Enemies Act, authorized the president, during an emergency, to exercise the delegated substantive power, i.e. to regulate importation by imposing an import duty surcharge or by other means appropriately and reasonably related to the particular nature and emergency declared. So the government's argument is that when Congress passed IEEPA 2 years later and gave the president the power to regulate, among other things, importation, it was hearkening back to those words from Yoshida International, and it meant to give the president the power to impose tariffs.
I mean, it does seem like kind of a back formulation,
You
right?
think?
I knew where you were going with it the whole time, and still I was like, man, I don't see it, man. But okay, I hear it. I hear it. Okay.
Yeah, and I guess I would say a couple of things to that, right? Number one, it was surreal to me to hear the government argue for this expansive view of statutory interpretation by citing these cases from the 1960s and 1970s, when the successful conservative judicial project of the last 30 years has been to narrow the scope of congressional delegations of authority, right? I mean, they blew up Chevron deference, for example, right?
Right.
Yeah.
Right.
And second, and we're going to get to this later on in the chain, Neil Catchall, arguing for the private plaintiff, said, okay, look, but if the government is going to live by Yoshida, they're going to die by Yoshida.
Yeah, let me jump in here, because Neil Katyal, in case you guys don't know, is one of the most famous, Supreme Court and appellate litigators in the country, and it's funny, his hourly billable rate is kind of the benchmark because he's got one of the highest billable rates in the country.
Yeah, it's like over $3,000 an hour now, right? Good work if you can
so
get it.
he argued this case. He's not charging the states anything like that. That's kind of a running lawyer's commentary. Like, how much of a markdown does he give the all of these pro bono people, because he is, I believe, at one of the law firms which caved to the Trump. He's at one of the Vichy law firms which caved to the Trump administration. Anyway, I think there is a very real chance that the federal circuit will say, no, that is not what IEEPA meant. We're not buying this whole, ratification argument. But assume arguendo that the federal circuit says, yes, okay, we'll take that. That's what IEEPA meant. IEEPA meant that you, Donald Trump, actually have the power to say emergency and then just steal Congress's tariff authority. That would tee up a second question, which is, if Congress really did delegate this power to the president under IEEPA, is that delegation itself constitutional? And that's the major questions doctrine, which we've talked about here before. It's really a Roberts Court invention from a decision called West Virginia v. EPA in 2022, where they said that if Congress had intended to give the EPA the power to regulate coal power plants, well, Congress would have had to say so explicitly. And while absent such an express delegation, we must assume that Congress did not intend to delegate this major question to the executive branch. Yeah,
Antonin Scalia pitched this argument for decades as, we don't look for elephants in mouse holes.
Right. And Katyal said something like, we don't look for a supernova inside a grain of dust or something. He was really feeling himself this morning. But do you want to unpack what that means for a second?
Yeah, because again, I don't want to say anything complimentary about Antonin Scalia, may he rot in hell. But this is not a terrible argument, right? it is that the court is not going to assume that there was a giant thing implied by something very minor, right? You don't presume that Congress was hiding its real intent to hand over the entirety of its tariff authority, right, in a list of things the president can regulate during an emergency. But as I just kind of steel-botted that, let's be very clear. The major questions doctrine is complete nonsense invented by the Roberts Court to try and stop the Biden administration from doing stuff. It's bonkers, right? The way in which we figure out what Congress intended to delegate to the executive branch is not to ask afterwards, hey, is this agency trying to do something big? Oh, yes? Okay, well then no, they can't do it, right? Like that's just crazy and regressive. The way we do that, the way we did this when we did real law was to look at the language of the statute. If the statute was clear, then, right, you just asked, does this thing that the agency wanted to do fit within the plain language of the statute? If the statute was ambiguous, we deferred to the agency's reasonable interpretation of the scope of its authority. But now we do neither of those things. Instead, the Supreme Court decides if it likes what the agency is doing, and if not, it says that the president can't do that thing because it's a major question, and so Congress needed to speak more clearly. Okay, but I'm kind of with the plaintiffs here, right? Like, as long as the bullshit major questions doctrine is being treated like it's a real thing, we might as well go on offense with it and use it to stop the Trump administration from doing stuff, right? Like if Biden could not forgive student loans, right? That was the Nebraska v. Biden case from 2024 that was invoked repeatedly at this hearing. Then Trump sure as hell can't steal Congress's power to impose taxes. That's crazy.
Right. So the argument here is that Congress, quote, rarely provides an extraordinary grant of regulatory authority through language that is modest, vague, subtle, or ambiguous. So if Congress wanted to hand the president the power to seize control of tariffs simply by shouting emergency and then, waving around a poster board with a bunch of country names on it, Congress would have said that really clearly, which it did not. And Trump's argument here, the mouse hole, is that Congress said the president can regulate imports during an emergency, and that was a hidden implicit delegation, and that means he can tariff every penguin in Antarctica if he wants to.
Yeah. So Catch-all started his oral argument with, may it please the court, I would like to start with the major questions doctrine. And then one of the judges said, yeah, I bet you would.
Yeah, I think that was achieved. It's a little dogleg, but it was so interesting to observe what was effectively a trade court, right? The Federal Circuit is a court of very limited jurisdiction, and it's not a particular area that's been really politicized.
Yeah.
And because it's not so ideologically riven, there was a lot of laughter. It was a much more relaxed atmosphere. If you listen to the Supreme Court, obviously it's the Supreme Court, it's going to take itself very seriously, but everyone there is really, really mad all the time. Alito and Thomas are pumped full of Fox News grievance, and Gorsuch and Roberts are constantly being so pedantic and sanctimonious about all the terrible discrimination against conservatives. And the three liberal justices are rightly furious all the time. And the circuit courts aren't that bad, but they're not great. They're often ideologically riven too. And even if they're not, they know that everything that they're doing is going up to a court that is functionally broken. Here in the Federal Circuit, there seemed to be less open hostility. It was a much more relaxed proceeding.
Yeah, I think that's exactly right because of the specialized knowledge and confined jurisdiction.
Yeah, and you and I were listening to it, and we were talking about it. And the parties here, both the government, Brett Shoemate for the government, and Katyal, and the Oregon Solicitor General, who also spoke on behalf of the states, they wanted to talk about really constitutional questions. And these judges, because they have such a limited jurisdiction, they want to talk about tariffs because that's what they do. That's their wheelhouse.
Yeah, I think that's right. And look, if I'm trying to read the tea leaves here, I think that what this Federal Circuit is going to do is, in the main, affirm the ruling of the Court of International Trade and kick this on the major questions doctrine, right? That is that they're going to rule that the lower court was correct, that there is no explicit delegation of the tariff power to the president, so he doesn't have it. And even if there was, that would exceed the power that could possibly be implied from that prior language projected forward via Yoshida International. And then we'll go on to the Supreme Court. And honestly, I think the answer to what the Supreme Court is going to do is going to depend on how bad Trump's tariffs have been for the stock market by then.
Yeah, I'm in agreement with you. Okay, we're going to take one more quick ad break, and we will be right back. Hang tight, you guys. And we're back. Yeah, I agree with you. I think that the Federal Circuit is likely to kick this case on major questions doctrine grounds. But okay, let's kind of play this one out. Suppose the Federal Circuit says that the case doesn't get disposed of by the major question doctrine. Suppose that they say that IEEPA did give the president the power to impose tariffs, and that's constitutional. That was a constitutional delegation. If so, then we go to like your second question that you said like 15 minutes ago. What are the limits of the president's tariff authority under IEEPA? Can he just like shout shit every other day and say like, now we're going to impose a 50% tariff on semiconductors, which is, like that's kind of how he's behaved.
Right. And this was the part that was the most interesting bit of legal geekery for me, because Shumate for the DOJ had to walk this very fine line, because on the one hand, he had to say, oh yes, there are real limits on the delegation of congressional tariff authority to the president. He's got to say that, because if there aren't, then there is not an intelligible principle, which is the legal standard to make it constitutional.
Yeah, I mean, just this morning, Donald Trump said, wow, Canada has just announced that it's backing statehood for Palestine. That will make it very hard for us to make a trade deal with them. Oh, Canada. And, it's very hard to say
that has a lot to do
this
with our balance of trade payments with Canada.
Right. You can't say that we're doing this because of some sort of trade deficit emergency or because our industrial manufacturing sector is down.
Or to stop fentanyl, which is their other justification.
Right. When you've explicitly connected it to something which has nothing to do with any of the supposed emergencies.
That's exactly right. And that gets to the other horn of Shumate's dilemma, right? So he's got to say, oh, yes, there are these very real restrictions on the president's powers, but then he can't agree in court that there are actual limits that Trump is going to follow, because Trump is going to continue to howl and, threaten to impose new tariffs on Vanuatu or whatever. So here's how the DOJ tried to square that circle. Shumate said that Congress placed restrictions on the president's authority to enact tariffs in both 50 U.S.C. Section 1701 and Section 1702. But then he argued that the 1701 restrictions, those are the real ones, right? That is the declaration of the emergency itself, that those are non-justiciable. They cannot be reviewed by any court anywhere. The only check is that Congress can terminate the emergency. And theoretically, sure could, but definitely won't.
Right. I mean, the Trump administration's regular argument in every one of these courts is that nothing that it does is subject to judicial review. Everything is non-justiciable.
Yeah, that's exactly right. So here's the game. Here's why 1701 has to be non-justiciable, because it says that IEEPA only applies to an, quote, unusual and extraordinary threat which has as its source in whole or substantial part outside the United States to the national security, foreign policy, or economy of the United States if the president declares a national emergency with respect to such threat.
Right. And if that were reviewable, Trump would definitely lose, because trade deficits are not an unusual and extraordinary threat, even by the declaration's own terms. We've had them for a really long time. Yeah. Although I will say this morning, there was this kind of extended discussion of like, well, if it crosses some threshold, does that make it an emergency, right? Can you say, like, obviously, if you have a little campfire or something, if your toaster catches fire, maybe it's not an emergency, but if your house catches fire, it's an emergency. Like, when does it cross into house fire territory? That was a kind of a long colloquy back and forth. But so Trump's executive order doesn't really answer that. It just uses the phrase large and persistent annual U.S. trade good deficits and distresses the structural framework over decades that has allegedly failed. So, by its own terms, that's not unusual or extraordinary.
Right. So they want that to be unreviewable. What Shumate says is reviewable are the exceptions to the grant of authority that are in the next section, section 1702. And multiple judges on the court tried to get it. He kept saying, well, there are 4 checks. And so multiple judges were like, can you say what those 4 checks are? And he never said them out loud. Now, in fairness, there were 12 judges peppering him with questions. This is a very, very difficult oral argument to tackle. Mm-hmm. But I think this was a deliberate choice, because here's what those 4 checks are. These are the things that the president can't do under the DOJ's view of the emergency powers delegated to it by IEPA. Number 1, they may not restrict any postal, telegraphic, telephonic, or other personal communication which does not involve a transfer of anything of value. Okay, so private
talk to people.
Phone calls. Yeah, right. The president can't tariff private phone calls. Okay, cool, Brett. 2, donations of food, clothing, and medicine for humanitarian relief. Restriction 3 is certain informational materials, and I tried to figure out what that is, but I think those are like the Radio Free Europe, Radio Liberty broadcasts. It's, in any event, it's another non-material, non-monetary restriction. And number 4, transactions incident to travel to or from any country, which I believe are the duty-free shops at airlines, right? Like, that's those are the restrictions that the government stood up in court and said, well, this is absolutely what's going to constrain Donald Trump's power.
Yeah, it's funny because I wasn't looking at those restrictions when I was listening to it. And I wasn't. Now that you kind of spell it out to me that's what it was, it's interesting because it did seem like he kept getting cut off, but it makes more sense now that what you're telling me is he didn't want to say it because these restrictions are so de minimis that they barely count at all.
Yeah, it could be 2 things.
All right, so let's talk about what's going to happen now. The Federal Circuit could reverse the trial court, the Court of International Trade's rulings. They could say that Trump is right on his reading of IEPA, or they could say, well, there's some issues that the CIT needs to decide. And in that event, they would remand back to the Court of International Trade for more fact-finding. But either way, delay is essentially a ruling in Trump's favor because Trump keeps announcing these tariffs every day, and courts have not told him to stop it. On the other hand, the Federal Circuit could affirm the trial court's ruling or find that the result, maybe they would have a different line of reasoning and get to the same conclusions. But they could say, no, there is no reason that Donald Trump has the legal justification to impose these tariff schemes. And I will say it is not normal for courts to sit en banc all the time. I mean, the Federal Circuit is its own weird entity, as is the Court of International Trade. But it is not regular for them to sit en banc. And I know that we were sort of frustrated when they stayed the trial judge's order, because that was a really strong, and that was a 3-judge panel in the Court of International Trade as well. I think we were pretty frustrated when they stayed that order. But the fact that they did hear this en banc, the whole panel, suggests to me that they are taking this quite seriously because they know that they are going up against the president who likes to do crazy illegal shit, an administration that will treat them as illegitimate. And so I think, I don't think it's going to be unanimous. I think you and I were sitting there and, you can never really count votes at an oral argument, but it appeared to us that the majority, and a pretty substantial majority of the en banc panel, was unsympathetic to the government's argument about having this expansive delegation of tariff power from Congress. And so, to me, I think they are gearing up to rule against Trump because they know it will be a big deal.
Yeah, I think that is exactly right on all counts. I expect that a lot of the media write-ups of this oral argument will say both sides got hit with hard questions, which is true.
Which is true.
Right.
Yeah.
And there were certainly judges that were skeptical, that seemed very skeptical of the arguments being made by the states and the private plaintiffs here. But we went through the roadmap, right? Like the Trump administration has to navigate the, skill and corruption. Like it has to walk such a narrow path to get there. And maybe that's going to happen at the Supreme Court. I mean, the Supreme Court has not had a great track record to date. But I think I'm glad, I said this to you or you said this to me, that I was really glad that this wound up in the federal circuit, because these judges were, they all to a person knew exactly what they were talking about and were able to ask these very pointed, specialized questions. And
Yeah. I mean, since you bring that up, I'm going to kind of unpack it really quickly, because there were all of these other lawsuits filed in the U.S. district courts. And the administration's argument was, no, they all have to go to the Court of International Trade. And there are some of those where U.S. district courts didn't kick them to the U.S. Court of International Trade. But most of them did get kicked. And it was clear that the administration thought this was going to be a better forum for them because it is a more conservative court. And I don't think that bet paid off. It certainly didn't pay off at the Court of International Trade, and I don't think it's going to pay off here at the federal circuit. I mean, we could certainly be wrong, or they could do some sort of half measure. We don't know. They could say IEPA did delegate this power, but we have to contemplate, think about all of the ways. They could kick it down the road by saying the trial court has to go back and make some sort of finding about whether this was a full delegation of power or whether this is a real emergency, et cetera, et cetera. But I don't think that's what's going to happen. I think that this is a circuit court of appeal understanding that they have to kind of hold hands because they know that the Supreme Court is so out of control and that they need to make it clear that the very particular court, which is, tasked with determining this question, has considered it fully if they're going to rule against the president.
I agree with that.
Okay, that is going to do it for us today, unless you are a subscriber at patreon.com/lawandchaospod or lawandchaospod.com, in which case we are going to have a really good, in which case we are going to get very silly in the subscriber bonus, because one of our favorite crazy lawyers, Stephanie Lambert, is back. She was kicked off one of the defamation lawsuits filed by Dominion Voting Systems because she leaked protected discovery, but she's like a bad penny. She's back again and in a totally different court. She's back in California. So that is going to be a fun one. Hope you can stick around. Otherwise, have a lovely weekend. And we will be back on Monday with written content and Tuesday with another show.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsa Media, LLC, all rights reserved.